Good morning. Thank you everyone for joining us today for our webinar, Mind the Gap, Inspection Ahead and Other Stops. Today's webinar and immigration update is being presented to you by Larry Linton of PwC. He's an immigration attorney located in Toronto, and we're very happy and excited to have him presenting this information to you. Good morning, Larry.
Good morning. Good afternoon. And from a foggy Toronto. I thank everybody for joining. And I had intended that this topic would be limited to the inspection regime that we have, but as typical in the practice of immigration law, particularly as a Canadian immigration law, many changes come very fast. So I've expanded the topic to inspection ahead and other stops. And you will see from the overview that I intend to spend a bit of time discussing the new government's immigration plans for 2016 and its priorities. Then I want to move on to the new electronic travel authorization and clarify its implementation. There has been some discussion about that. Then I do want to return to the topic of a case study, particularly in the case of an inspection that was conducted by immigration under the International Mobility Program. Up to now, all of our experience has been under employer compliance reviews with respect to the Temporary Foreign Worker Program, and this is the start of the new regime under the International Mobility Program. And then briefly, I just want to highlight two work permit categories for those involved in film and live theatre, as well as a new example of a business visitor for film producers. Obviously, at the conclusion of this presentation, I would welcome any questions that you may have on these topics, and really anything else that you want to ask. Maybe we can even conclude this as a sort of a ask the expert. I can't promise to be the expert and know all the questions, but I can certainly give it a go. So, let's proceed. The first slide is with respect to the new government priorities that have been set for 2016. And this is a result of an election that was held in October 2015. A new Liberal government was swept into power, holding a majority, and they campaigned on promises to review and reform some of the more controversial aspects of the immigration law and policies that had been implemented over 13 years of conservative government. So in a way, it's a reversal, or as I like to call it in Michael J. Fox's case, back to the future. Because a lot of the levels and priorities essentially are reintroducing those policies that were introduced by the previous Liberal government. But to start off with, firstly, I just want to give you an overview of the numbers. There is an overall increase of 7.4%. The economic stream, however, is down 11%, but front and center is that in the family class admissions and family unification has increased or will increase by 17%. So there's a new immigration plan. Front and center is the family class where the government is focusing on the reunification, compassionate grounds, as well as addressing some of the economic streams. In that, what the government has committed to do is firstly to clear the backlog of the pre-express entry applications by the end of this year. As we all know in immigration, the express entry program was introduced to become the new management tool of the selection of economic immigrants. And at that time, the government of the day put a cap on all the other applications, and the new government is now committing to clearing the backlog of those cases and then start tweaking with the express entry itself. We do expect that the point score or the comprehensive ranking system will be amended to allow for applicants to claim extra points for having siblings in Canada. And we expect that the Canada Experience Class program will be reformed to allow and reduce the barriers for international students to obtain permanent residence. The stream of international students has always been a pain point because the express entry does not give them, without a job offer, the opportunity for international students to gain permanent residence. So that is welcome news as well. When it comes to the family class, we have heard that the government intends to remove the 2-year conditional visa for sponsored spouses. This, in practice, has led to a 2-year conditional visa when they arrive, and if the marriage breaks down, there are enforcement consequences, and the Liberal government is reversing that, so that when you arrive, you are a landed immigrant without conditions and any terms. The other change is to go back to the maximum age for dependents, and that is going to apply to every stream and every application that affects dependents. The Conservative government reduced the age of dependency to 19, and that excluded a lot of temporary foreign workers as well as family members immigrating or hoping to immigrate with their family, so that caused hardship. But the Liberal government is returning to dependency of 22 and under. The government has also committed to a review of the temporary foreign worker program overall to increase transparency and integrity. Those are the two buzzwords that they used in the press announcement. And also to remove the visa requirement for Mexican citizens. This was introduced years ago, and it also has had a dramatic impact on, the movement of foreign nationals under the NAFTA, and we are pleased to hear that the government intends to return to a visa-exempt position as far as Mexican citizens are concerned. Citizenship is another hot topic, and the Conservative government introduced many restrictive changes, and the Liberal government is going to review those changes. Firstly, it is to reduce the residency, the overall residency requirement back to a 4 out of 6 years, and also to restore the residency credit that students and temporary foreign workers and those on other temporary status could accumulate towards the residency obligation. The Conservative government had intended to ditch that. So overall, these changes are welcomed. The Liberal government has been very vocal and pushing forward with their campaign promises, and to a large extent these changes will be welcomed in the immigrant community. The temporary foreign worker program, we hope, is also looked at and liberalized, excuse the pun, but we do think that the enforcement mechanism that has been introduced is too early to be amended and changed, and it's only a matter of time, maybe before that is reviewed as well. So these are the new playing field of 2016 and beyond. A new topic is the electronic travel authorization, and this was introduced effectively yesterday. And I just wanted to go through some of the qualifying criteria and the exemptions, and really it's a bit cloudy because there are exceptions to the exceptions. So firstly, the lead statement is that this applies to all visa exempt foreign nationals flying into Canada by air. So that's the first bold statement. So the first exemption is that it doesn't apply to visa required individuals, but visa exempt individuals can apply. And it's only by air, whereas foreign nationals arriving by land and sea are excluded. Work permits and study permits that have been approved outside of Canada between August and August the 30th, I think it was, and yesterday, March the 15th, were issued the ETA as part of the application. So the exemption there is that it's for work permits that have been applied for outside of Canada, but it doesn't apply to work permits that are currently being processed through the case processing center in Vegreville, for example. Those individuals who get their work permits and other status documents in Canada, if they do travel, will have to get the ETA to secure their returns. Citizens of the United States are exempted from this requirement, but it doesn't apply to those green card holders or lawful permanent residents of the US. So that's something to keep in mind. And Canadian citizens and permanent residents themselves are exempted, but not those permanent residents whose PR cards have expired or will shortly be expiring. So it's important to bear in mind what the rule is, what the exemptions are, and then what the exemptions are to the exemptions. The good news is that the enforcement of all of these provisions have been deferred until the fall of 2016. We don't know what date that is, but we do know that the regulation has taken effect. So our advice to clients is to nonetheless apply for the ETA because it's a straightforward application. You pay $7 and it's an online process and it's valid for 5 years. So we are encouraging people to apply for them. Don't wait until you are stranded overseas and you apply before the rush of the ETAs. So what I just wanted to clarify and drive home the point is that there was some misunderstanding about this deferral. It's enforcement of the ETA, the enforcement of the requirements of the ETA that have been deferred. The fact that you need an ETA, that is still implemented and will be required. So electronic travel authorizations. I now want to return to a sort of a practical example of an inspection. And this happened to a client recently of ours. And the topic of this is, we hear knock knock, and that's sort of a change to the joke, knock knock, who's there? Because now under the inspection powers, literally immigration can come knocking without an announcement. The good news in this particular case was that the client, in fact, was contacted before. The request was then reduced into writing and by letter, which I'm going to go into in a moment. And it was a first example of the international mobility stream inspection. As I said at the beginning, there has been more history based on the employer compliance reviews under filed LMIAs. And this was the first time that we are talking about an INP work permit. So what happened is that this was a random inspection. There are there are 3 types of inspections, and they all must be triggered. And in this case, the employer was chosen as part of a random verification of compliance. And that is set out in the immigration regulations, which mirror to a large extent the conditions that are imposed under the LMIA process. But what the employer was asked to produce and to comply and to confirm their compliance with was with respect to wages and occupation, working conditions, evidence that they provided a workplace free of abuse, that the employer was actively engaged in business, and that they were in compliance with federal and provincial laws. So it really repeated word for word what the conditions are based on the Section 209 in the Act. They were required, the employer was required to report and provide the documents and attend any inspection that would have been forthcoming after the supply of the documentation. And the letter goes on to allow for the non-compliance based on certain prescribed justification provisions. So what typically happened is that the documents were gathered together, and we had to show basic documentation with respect to a foreign national. Thankfully, only one foreign national was isolated for that inspection. We assisted the client in putting together copies of the work permit, the offer of employment, the original submission. In this case, we were dealing with an intra-company transfer, and it was an individual who was here on a full-time basis, not the other example of a temporary foreign worker coming in at the request of a foreign or US employer. So the documentation was extensive in its request, but the good news is that the client was able to show complete compliance with the terms and conditions of all of the sections. It was relatively straightforward in that sense. The officers were pretty engaged. I was dealing with one particular officer, and he was coaching us through it because it was one of his first inspections as well. You could send everything by email, and that proved to be useful. So that is really what the extent of the request was. And then when we go into the details, it actually followed a lot of the same conditions that were required in the employer compliance review. In other words, to demonstrate compliance, the client was requested to show payrolls, timesheets, explain any discrepancy, to talk about in the working conditions section, to show health care coverage, any accommodations, any transportation costs. For the occupation condition, to just talk about the employment of the foreign national, and description of the duties, the educational requirements, the location of work, and evidence of the business in terms of being active in business and had to present business license, Canada revenue documentation. So really the extent of the documentation similar to the ECR. So that is really the example. I guess the practice tip is to ensure that your records are compliant and full and detailed, that you have all of this documentation ready, on the assumption that you may not get a letter, you may not get a call, and as I said, you may just get a knock at the door. The other point is to keep the immigration file separate from the personnel file. You don't want to turn over all of the details to the inspector. You want to limit that issue. That is the factual background. Then it turns to the determination of non-compliance. I mean, what happens in our practical case? The employer was found compliant, so we didn't have to get into this whole debate about non-compliance. But it's worthy of discussing what the consequences are, because in December 2015, a new regime was brought into place that expands the consequences of non-compliance. Prior to December, and the date of that is based on the violation date. It's not the date that the inspection is triggered. It's the date of the violation that could lead to a finding of non-compliance. So with respect to violations pre-December 2015, the punishment is essentially limited to the publication of the employer's name on the public website, a ban of 2 years from using the temporary foreign worker program, and the revocation of work permits. After December, And I guess now we're going to start seeing that perhaps a steady increase on these dates of violations post-December. The enforcement regime is more extensive because you can have a warning in a less serious finding of non-compliance, but then you have this scaling up of administrative monetary penalties, and that depends on the severity of the violation, the number of violations, the history of non-compliance by the company, and that is all formulated in a point system where the more serious, the higher the fine, and the more serious the imposition of a ban that could also be leveled against the employer. And that ban could be anything from 1 up to 10 years, and even in the most egregious cases, a permanent ban. So the enforcement issue in terms of employer compliance, as I said at the beginning, is sort of front and center, and we expect that this type of inspection is in fact going to replace the employer compliance review. So you'll have this inspection under the regs as the front and center to substantiate employer compliance. Lastly, I just wanted to talk about some new LMIA exempt work permits. Traditionally, those involved in the film and television production had to obtain a labour market opinion assessment. There was a special stream at Service Canada who would review these applications on an expedited basis, but we're now seeing some movement where an LMIA is not required at all, and that is with respect to foreign workers who are essential to a television or film production, and those foreign nationals working in orchestra or live theatre. And also, a further example of a business visitor has been introduced to allow for film producers and other essential personnel to enter Canada as a business visitor where a work permit is not required. So that is really a very brief sort of snapshot of where we're at, where we're going with immigration, and that concludes what I have to say. I'd be more than happy, as I said at the beginning, to turn it over for questions. And Christian, back to you.
Thank you, Larry. If anybody has a question that they would like to ask or post, you can use the GoToWebinar tool. There is a section available for questions, and you can post them. We will give a few minutes to see if we have any questions. And if we don't have anything come in, we'll just let everybody know that we did record today's webinar, and I will be sending out the link to all of the attendees at the conclusion of today's webinar. We're just going to wait a few minutes here and see if we get anything. It was very informative, Larry, so we may not have any questions from the audience.
Oh, okay, no problem.
Okay, I think we did get one. Let's see here. Okay, Larry, I did get a question, and the question is, do the essential personnel exemptions apply to animated films or only live action films?
Good question. The bulletin itself, I'll have to just quickly ruffle through my notes here, if you don't mind. I just want to see if it defines who they are. Just bear with me.
Mm-hmm.
I will answer
Certainly.
that question. Here we are.
Okay.
It talks about essential to a television or film production and would create and maintain significant economic benefits. It doesn't really specify, to be honest. So I will answer that question by saying that it probably covers both. I don't see a difference between the two, media. It's not broken down to that degree. So I'm inclined to say that codes would cover both of those situations.
Okay, excellent. Okay, so we have not received any more questions. I will be sending out the link today to today's recording. If you think of any questions once you receive my email and you would like to post the question to Larry, just go ahead and reply to the email and we will make sure that we get your questions answered. Thank you, Larry, very much for bringing these most recent Canadian immigration updates to us, and it was a pleasure having you present today.
Right, thank you for your opportunity. Thank you.
Thank you. Have a good day, everyone.
Bye-bye.